It's my pleasure to come back to in-person meeting or hybrid in-person meeting. There are about 300 plus people joining us online, but we have a full room of nearly 100 people here at our premises. My name is Loukas Mistelis. I'm a professor at WilmerHale. I've been here for the last 23.5 years. And it's my distinct pleasure to invite you to welcome our distinguished speakers today to this co-curricular seminar. The co-curricular seminars are an idea of our founder, Professor Julian Liu, and the idea was to pick up topics that we cannot really meaningfully cover as part of our normal LLM curriculum, often because they move more towards areas of practice, or because they're so specific that that, as interesting as might be, they might not sort of belong to the main curriculum that we have to deliver. So this co-curricular seminars is the 4th year we run them, and this is the 2nd for the academic year. The previous one was led by my colleague and focused on guerrilla tactics. How topical in the current political environment. So the topic today is about case strategy, how one would develop an appropriate strategy for a case, and how advocacy would be delivered. And one thing about advocacy, I remember a few years back when I was asked to review 2 books for Arbitration International. And the 2 books were 2 alternative books. One was a book by my friend Franz, called Arbitration Interactive. And the other was not a book, but it was a series of books and DVDs, or it was actually VCRs originally, organized by the ITA, the Institute of Transnational Arbitration. And I think the problem with both of them is that Arbitration Interactive has a very nice sort of story and explanation, but it doesn't give you alternatives. It presupposes that there's one style of advocacy which is right, and that's what you should do. And there were sort of, Klaus-Peter Berger was working with the late Martin Hunter, and so there was common law legitimacy to that, but to some extent is not necessarily the advocacy that one sees in cases. And of course, if one looks at the ITA now reasonably dated videos, as good as they are, at the same time, they have their own limitations. So they are scripted, they are performed in a hotel with a live audience. So you know that lawyers can be very good advocates, but they're not very good actors. Some of them are, but not the majority of them. So, and that prompted in approaching the topic from very much a comparative perspective and the cultural challenges that all arbitration lawyers have appearing in front of a mixed tribunal, how we have to leave some of our baggage behind in order to be able to communicate. Because technically, advocacy is communication. You need to communicate your case in a persuasive way for the tribunal to be reasonably comfortable to accept your position. And for that purpose, I have invited first to my left, Franz, who is the deputy chair, I think, or is called of the International Arbitration Group at WilmerHale. Franz is Austrian, but he was educated in Austria and in this country and practiced in so many different jurisdictions. And then to his left, and that's not an ideological position, maybe it is, Sarah Vasani, who is American, but has been in Europe for a long period of time, and she's now the co-head of international arbitration for CMS, based in London. And if you read their CVs, you will see that there are most continents and a very large number of countries that they have been involved in, either as a matter of applicable law, parties, or indeed the jurisdictions where they have sat. And the other very important aspect I wanted to make is that they both have experience as a counsel and as arbitrators. And perhaps also I should add that Franz was the inaugural award winner of the Swiss Arbitration Association Advocacy Award, which is a few years back, 3 or 4, something like that. But that doesn't mean that one is better than the other. there's so many good actors that never go to Oscar. So, so no one should be feeling intimidated by that. So I will move back to my chair, and what we will be doing is that I think we need to make sure that the remote audience can see us, and that means I need to stop sharing the slide so that they can. We would happy to do that, and then we will be seated, and what we were going to have is effectively a dialogue because there's so much to cover. Feel free to ask questions while we're going along, but if you ask questions for the benefit of everyone, and I will also sort of getting questions from the online audience, please state your name and then your question. So I wonder whether we have a number of questions, but before we go to the questions, I wondered to what extent advocacy was the reason why you did law.
Go ahead, please.
So I think it was a huge reason for me. I grew up on a steady diet of US courtroom dramas, and found that totally fascinating. And I knew that I did not want to be a transactional lawyer. I think actually to deserve the name of lawyer, you actually need to be litigating things. And it's definitely what brought me to the field, and it is absolutely the reason that I'm still doing it with joy and passion.
Yeah, I think it's the same for me in the sense that I remember growing up watching LA Law and
Perry Mason
or Ben Matlock, and all these different lawyers and how they would perform. And of course, it almost never happens like that in the real world. You almost never get someone on the stand and kind of, make them just admit to everything that you want. It rarely is.
I don't know, it does though.
Well, typically, first of all, we're usually not cross-examining murderers, and usually it's not quite as dramatic as it is in the movies. But I think there's that aspect of, getting to the truth, and especially in the common law system of being able to find out and really grill someone on the stand and make them sweat around the collar. And there's always something interesting about that. So I think that's definitely part of it.
Although in terms of popular culture, I don't know whether you have ever watched The Damages.
Yes.
With Glenn Close. I think there were aspects of cross-examination and the positions which are really very close to real life.
Yeah.
I thought the must have been
amazing series. Yeah.
That's for the commercial break. That's
lockdown. Yeah.
That's FX, yes.
Or The Good Wife, while we're at it.
Or The Good Wife, yes. So I think one of the things that people, of course, forget is that until we get to the advocacy, what would normally happen is that you will get a client who will come to your office or call you or whatever, send you an email first. And effectively, we ask very much like a counselor, sort of, they're very upset, they've been wronged, they have a particular sort of understanding of what went wrong, and a series of facts comes to you, but that's not yet the case, and perhaps it's very far from being a case. What will you do then? Sort of to how you start sort of take a set of facts which are very amorphous to create them in a case that could have a chance of succeeding.
So I think, but first of all, I think it's a great question, because we do all think about it as the stuff that happens in a hearing, but in fact, it actually starts in that very moment, the advocacy, because advocacy is so much preparation. So by the time you are at the hearing, you can only be a good advocate because you've done your job, right? So I think that's an excellent question. The way I tend to think about a case or structure a case is on 4 levels. I have sort of 4 case theories. One is the legal case theory. So what are the legal questions involved that get me to a certain result, right? The other is the factual case theory. What is the set of facts that I need to get to that result? And those are obviously very intuitive levels of analysis, and most lawyers are very comfortable with them because, we deal with law and we deal with facts. There are cultural differences, because you mentioned that earlier. I find that civil lawyers or civilian lawyers tend to start with the law, and analyze that and then try to find the facts that fits their legal theory. Whereas common lawyers tend to start with the facts, with developing a narrative, and then look what case or what legal proposition fits that story. I think none of these is good or bad. I think it's just sort of a cultural difference that is sometimes worth thinking about. But where then it gets really interesting is the third or fourth level. The third level for me is the persuasive case theory, because the law and the facts may be leading you to a result, but ultimately what makes compelling advocacy is to give the tribunal a reason why you should win that transcends the law and the facts a little bit. And that could be a narrative of equities, that it's the right outcome, the fair outcome. And I don't mean this in a sense that you're making a plea of fairness that is desperate. But every legal rule is there for a reason, right? It's a value judgment in the sense that the legislation has made. And so you have to think about what that means for your case. Why is it not only sort of on the paper of the law, the result that you want? Why is it the right result that someone should move in the direction of your client? And that's, I think, where the real advocacy starts, when you start thinking about that. And then very briefly, the fourth level for me is when you have all that and you get a sense, is this a case that you can win, or how hard is it a case to win? To then think about real strategic questions. And the first question with your client is to define what winning means, right? Because, as a lawyer, I know what winning means, which is obliterating the opposition and just getting an awesome award. But the client obviously is in it because there is a commercial interest in the case. There may be a matter of principle. And so defining what winning for the client means, I think, is really important. And if you put all of that together, I think then you can work on a case and get it to a good conclusion.
Yeah, that's interesting. I usually start where you end. So I usually start with, what does the client want? It's their case. Clients have different interests. It might be the fact that they want to approach this very aggressively. They might want to approach it softly. They might want a negotiated settlement. They might be operating in a country where they have other interests and they need to maintain good relationships with the state, if we're talking about an ISDS case, or if it's a commercial partner and it's a long-term partner and they want to continue the relationship, you might approach that dispute very differently. I also, ask what the budget is, how much do they want to spend, how quickly do they want to get it done, because all of these are commercial considerations that might lead to an entirely different strategy. If I've got $1 million to run a case or $20 million, it's going to be a very different case, right? And it's also going to be different depending on what the client wants. And then similar to Franz, I think I'd usually do kind of a initial, I call it a spine check. You kind of start from, well, first of all, is this a commercial case or is it an ISDS case? And then I start with jurisdiction and merits and quantum and enforcement and think about it in terms of kind of the red flags of those cases. Is it a winner, or is this something that actually, unfortunately, sometimes you have clients that come to you with a case that is just not a case, so they want to sue Egypt and they're Egyptian. And you have to explain that that doesn't work for the, but they might say, well, this person did it. Well, no. So you have to really think, what is the goal here? And do I have, any particular issues that I'm going to have to flag up? And then, when you're done doing that, you have to really get into the peculiarities of jurisdiction, and it's often the case where you'll be strong on jurisdiction, but not as strong on the merits, or you're strong on causation, but not as strong on quantum, or there might be an enforcement issue. So you really have to weigh up. And I like to think about it like a poker hand. You've got different cards that you're going to play. So you have to think about how you kind of interact the strengths of your case with the weaknesses of your case to kind of create a theme and a narrative. And then Franz, I think we're very much storytellers, don't you, as lawyers? And you want to tell a story to the tribunal that's convincing and compelling, and that does hit upon the equities. And then finally, I like to think about it as an arbitrator. and think about how I would view this case if I was the one judging it. I think earlier on in my career, I was very much, I just want to go in there and get them and destroy them. And then sometimes when you sit as arbitrator and you have that party in front of you that is kind of not grappling with the adverse evidence and really, going full speed at the wall at any case with their theory of the case, even when it doesn't entirely make sense, it's not convincing. So you have to think, what is going to convince the judge? Who am I speaking to? And how can I convince them? And so that's usually the end for me, kind of starting with what the client wants and then looking through the case, kind of the red flag analysis, and then finally what the tribunal would think.
When I was doing my training more than 30 years ago, not my pupil master, but one of the senior lawyers in the firm, the first thing he told me is that one thing that you need to know from the beginning as a young lawyer is that often the enemy is not the other side, your adversary, that just do the job, but it's your client, because your client will give you a version of the story, which they think is the story that they have developed in their heads, and they think that they're convinced about the story, they will give it to you. But then you go ahead and you realize that there are aspects in the case that you never considered that they were there. The letter has never been disclosed or something else never been discussed. How much of an investigation would you do at this very early stage? And is that sort of very preliminary stage still advocacy or not yet?
Yeah, so for me, well, unless I'm pitching for a case in which that is actually very much advocacy, advocacy really starts when I'm presenting something to either the other side or the tribunal. But I agree with you at the very beginning, you want to get as much information as you can from your client, because your advocacy can only be as robust as the information you have to back it up. Now, there are times when that's not possible. You might have a statute of limitations that's going to toll. You might have, I've had situations before where something else was going to be filed in another jurisdiction and we needed to beat the other side to it. So really, I think the advocacy will depend, and how robust it can be will depend upon how much information you have available. So if you really have only bare bones, you'll probably submit an RFA or an NOA that's very high level, that's very bare bones and doesn't go into the details, because what you don't want to do at that stage is either overstate your case or misstate your case and therefore lose credibility with the tribunal because you can't get it back. So, on the other hand, if you've got a client, and there's not as many of them, but some of them have, come to you with electronic files of everything that was ever said on the case, and they hand everything over and there's chronologies and it's beautifully documented and you have all the evidence before you. In that case, you can then prepare a very robust RFA or NOA, and that might lead to a different outcome. It might lead to an increased likelihood of settlement, for example, or sending a particular message to the other side because you've got all of your ducks in a row and you've already seen, all of the evidence. So it really, I think, depends upon how much you can get out of information you can get from your client, and then, knowing as much as possible as soon as possible.
Yeah. So, I just very briefly, I couldn't agree more. And it's sometimes just a matter of timing or urgency, right? Because you sometimes are in a situation where things have to move very fast and you have to move with what you know is limited information. And I've just had a discussion last week about a request for arbitration within our team, because I told the team, can you draft something, right? And I want this to be very high level because things have been moving very fast, and so make it very short. It's fine. We'll have time to state a full case later in the proceedings. And next thing, and in the inbox there's the request for arbitration. I open it up and it's 37 pages, and I read it, and it's a totally compelling story. It was really brilliantly written, but I'm like, I don't know that any of this is actually true. Yeah? So no, that's not what we're going to file, and it's not wasted work, because we're going to use all of this hopefully at some point. But I just like you, I'm obsessed with by fear that you say something at the beginning that comes back to haunt you, and so I rather say less. I'm completely with you.
But I think that's why you get, for me at least, the written advocacy is really at the reply stage or the rejoinder phase, because by then you've had you had a response from the respondent, you've gone through document production, you know who your decision makers are, you know who the tribunal is, so you can really crystallize your advocacy and the reply and the rejoinder. Whereas the initial pleadings, there's always there's always surprises. Even if your client is in great shape and they give you lots of documents, something will always come up that you'll have to deal with. So it's really at the end, those two pleadings can really advance the case and crystallize the case and really have robust advocacy, because you know as much as possible. You know everything you're going to know usually at that stage.
No, I think the point you're both making is very pertinent. I think credibility is key for an advocate. Of course, tribunals cannot be sort of influenced incredibly negatively if something is not accurate, because they know that mistakes happen. The case has been, I remember a case with a very famous team where they were suing a non-existing party. And after the terms of reference, there was a request to amend the terms of reference, but there was not an amendment of the terms of reference. It was withdrawing a claim in respect of a whole sort of line of argument. So, and they knew that perhaps did not look the right way. But obviously, a lot of this planning and sort of the case planning impacts in the roadmap of the case, where, for example, you're going to ask for summary dismissal, whether you're going to bifurcate. So I agree, it's not yet advocacy, but in the long run, it will impact on how things will be done. So, Franz, when do you think real advocacy starts then?
I think it starts very early in the preparatory phase, because it's the basis for the advocacy, but in a more sort of widely accepted notion, it probably starts with the written submissions, and then it gets, like you just said, Sarah, more intense with every step, and cases evolve. I think the rebuttal rejoinder phase in writing is super important. For me, the hearing and the oral advocacy is why I'm doing this. That's the fun part.
Yeah, no, I agree with that. I think, sometimes if you've got really astute clients, you might actually be involved before there's anything written to the other side or a dispute is actually filed. So a lot of times clients will get you involved when they think things are going badly in a transaction, and all of a sudden you can tell when a lawyer has gotten involved. So
right.
all of a sudden the language sounds a little bit different. We're citing specific provisions of the contract. And so, really it starts at that stage to make sure and really to counsel your client on the things they should be doing, so that if a dispute does ever arise, they will have the documents, they will have the information, they will have the right set of tools that you'll need to employ to win the case. So really, it can start much sooner than the actual filing of any cases.
But I think what you're both saying is, because you don't know where you start, it really starts when you write the first formal communication to the other side or to the tribunal. So how important is writing the very first letter to the tribunal then?
Yeah, I think it's your first impression that the tribunal will have of you. And, it's really compelling, because once you sit as arbitrator, I think I've learned more doing that in terms of how you perceive the other side than any, counsel work, because all of a sudden, small things matter, being quite precise. If things are misspelled or, things aren't aligned, it just really, or the indexes aren't done properly, or the evidence is hard to find.
Our name is misspelled.
Yeah, the name is misspelled. It really kind of leaves this impression. You try not to let it affect your judgment, but it really does matter how things. I used to have, sometimes we have one particular paralegal who's brilliant at making everything perfect and lovely, and that really matters. It's like a presentation that you get from the parties, and it impacts how much you're likely to believe what they're telling you. Because if it's sloppy and it's not professional, you lose some confidence that what they're telling you, they've actually researched and that it's correct.
Everything's about credibility, right?
Yes,
and
absolutely.
It's just an important part of advocacy. As you said earlier, credibility is sort of the coin that you pay into every case. And that's part of credibility, to have just something that is well put together, that isn't riddled with spelling mistakes. As silly as that sounds, I think it's really, really important. And I also think that, correspondence is absolutely advocacy, because quite beyond what you're actually saying in the letter, you're always sending a message, and you're sending a message and a signal to all the players. Sometimes you write a letter to the other side, but the message is really for the tribunal.
Yeah.
Sometimes you write to the tribunal, but the message is really to the other side. And that's advocacy, to think really about what message you are saying, but what are all the other things that you're implying for the, and who's ultimately the audience of your message, right? That may not be the person who's the addressee of the letter.
And that might end up before the tribunal as well.
Exactly.
So, always be very conscientious that whatever you say to the other side, unless it's without prejudice and there's an agreement that it won't be shared, often does come up before the tribunal, and make sure that you're conducting yourself accordingly so that you don't lose any credibility in that respect.
And sometimes you want it to end up before the tribunal.
Yeah, absolutely.
If you're extra sneaky.
Yeah, you set a trap and then there's been a response, and then you take it to the tribunal.
So, but would you argue that even the selection of the tribunal is advocacy? Or is part of your case strategy?
It's certainly part of the case strategy. I think it's commonly said that it's the most important decision that you make in the entire case. And that's absolutely true. It's also the reason why you need to have a pretty decent case strategy when you make that decision, right? Where are the strengths and weaknesses of your case? Is it more a legal case? It is more a factual case? Is it how will a common law, how will a civil law arbitrator react intuitively to the argument? Do you need someone who is very commercially minded? Do you need someone who will be receptive to a technical argument, because that's sometimes what you have, right? Do you want someone who's very high level, big picture, natural law, justice and fairness, or do you have a case where you really need someone to get into the weeds? I mean, these are all sort of decisions, basically, because they're presentational decisions and they need to be reflected in the tribunal that you choose.
So how would then you react to a statement that has been made, that one important rule for advocates is not to fall in love with their case? Keep a distance as much as you can. Do you think that's realistic or is not realistic?
So if you ask me to agree with you, I'm contrarian by nature, so I will disagree with you. I understand, of course, where you're coming from when you ask that question, because it's said that love makes blind, or love is blind. And what we mean by that is that we love something so much that we stop seeing the faults in the other person, right? And you don't want a lawyer who can't see the fault in the case or the weakness in the case. You want someone who is aware, acutely aware of where the weaknesses are, so that she or he can be a proper advocate in the case. So having said that, I do think you need to love your case to an extent, because you need to come to a point, my very, very personal view, I think you need to come to a point where you've dealt with the strengths and the weaknesses in a way that what you are presenting, you actually believe in. Because if you don't believe it, why should anyone else? Why should the tribunal? And I think that tribunals, they sniff it out. If you say something that you don't believe, they will know. They will get that vibe. So I'm not talking about sort of being in love and ignoring the faults in the case, but I'm talking about a mature kind of love that has worked through the issues and is then committed to the case.
Yeah, I agree. I mean, you have to be impartial, and you have to keep a real sense of your strengths and weaknesses of the relative case, but you have to believe in your case, and you have to want to win for your client. Because I think when you're advocating before a tribunal, they can tell. I mean, they can just, it comes across really clearly when someone's uncomfortable with the position that they're arguing. And there's always times that we'll have to make some arguments that are colorable, and they're not arguments that we love. But I think tribunals can really see if you believe in your client, if you believe in your case, and if you're really, let's say, fighting for justice, right? And I mean, typically in my career, I luckily have usually been on the side where I really did feel that my client was wronged, and I wanted to fight for them, and I wanted to win for them. And it did,
Isn't it funny how that always happens?
It always happens to me somehow. But with that being said, I think the thing that you have to be careful about, and I think goes to your love is blind point, is that you have to be careful not to have confirmation bias. So if you believe in your case and you see your case a particular way, and then new evidence comes in, it comes in through disclosure, it comes in through new pleadings. And because you're so wedded to what your case once was, or that initial story, that initial theme you put forward in your statement of case, that you just aren't dealing with that evidence, grappling with it and putting it into your narrative. Because I think what tribunals do not find compelling is when you just ignore. And I have a case right now where the other side just ignores the bad evidence. They just won't deal with it. And it is so uncompelling. You have to be willing to say, yep, okay, that doesn't fit anymore and I need to adjust. Otherwise, if you just have the same view of your case, no matter what, you will lose a lot of, I think, persuasiveness when you're trying to persuade a tribunal.
I think there was a question.
Yeah, just a follow-up question. I'm Lisa Shetmark, by the way. Did it ever happen to you that you were in the middle of a case and there was evidence that came up where you couldn't be convinced by your argument anymore? Like, what would you do in a situation like that where you simply can't believe what you argue in that instance?
You want to go first?
Well, yeah. So I've had surprises come up either in disclosure or in pleadings or on the stand, frankly, where you've been dealing with a witness and you think you know what they're going to say and they don't say that. And you think, my God, what's happening right now? I think most things you can come back from if you. There's very few times where one document or one statement is going to blow the whole case, right? So I think then you have to deal with it and you have to be open and honest with the tribunal. Okay, Mr. X just said this, that has this impact, and you have to own it. It's your case. I mean, we all have children, and sometimes they're not fun and beautiful. Sometimes they cry and they're snotty and they have vomit everywhere. So sometimes your cases do too, and so you have to deal with those warts just like you would. But I think you then have to try to save the case by looking at, okay, this doesn't affect the fundamental tenets. And if it does affect the fundamental tenets, sometimes you have to lose, sometimes you might have to give up an argument and say, you know what, I no longer maintain that position because it's clearly not right. And I think you win more points with the tribunal by acknowledging that, as opposed to trying to argue something that just doesn't hold water.
Completely agree.
Thank you.
I have actually two comments. One on just before Lisa's question, the point Sarah was making. I think in some legal cultures, particularly civil law, you don't deal with evidence which are adverse to your case. It's absolutely acceptable not to touch them. That's a way of training. So you can see why some of this practice happens. But the fact that a star witness, sometimes your client, on the stand really disappoints you, or that something comes up. I think that part of it is just part of the strategy. You always have to have a plan B.
Yeah.
So when you develop your case, and that's very typical, effectively, but not exclusively to in investment cases where client says I have my company is incorporated there, and then the evidence seems that it's not exactly right. So there has to be always a plan B in the planning, so that the advocacy, so that the moment of the hearing will not undermine the case.
And that's just, I would say, that's why documentary evidence is so important. I mean, witnesses are, everyone thinks of hearings as, the witnesses, and that's going to make or break your case. It is true that you want to have a likable client. You want to have someone that's credible and truthful and that, tells their story to the tribunal. But at the end of the day, even the most honest of witnesses, I cannot remember what I ate for breakfast. I don't remember what happened 10 years ago. And I think there's been a lot of now research on memory and how reliable witnesses really are. And so, ultimately what the tribunal will be most comfortable with is basing things on the documents. So make sure, this kind of goes without saying, but make sure that your witness statements do not contradict the documents and that they are grounded in the evidence that existed contemporaneously, because contemporaneous documents are what wins cases, I think.
Yeah, I completely agree with the psychology of witnesses and the reliability of memory. In fact, very early in my career in Austria during my training, I clerked at a court that did a lot of traffic accidents, you know? And you have witnesses detailing they were riding the car, or they were crossing the street, or they were riding a bike, or whatever, and then the accident happens. And obviously, in a trauma situation like this, you know, I mean, it's clear that that these witnesses often were not lying, you know. But then you have the expert who looks at the black rubber and how long it is from the car braking on the road, and says, you know, it just can't have been this way. Yeah? So I agree with that. Having said that, I've also had a number of cases where a document looked pretty clear on its face, but actually what the parties meant at the time was different from how perhaps you would read it. So I agree, and I think the document, the contemporaneous documents are how you can most reliably build the backbone of your case, for sure. But I think you always have to keep in mind that how you read it so and so many years after the fact might not also actually always be the way it was meant. So,
but I think also what you're saying is that you really need to sort of have a peripheral view of the documents, not just what is on the face of the document, but you need to look at context. And then obviously one of the big jobs of the advocate is to make the case tangible for the tribunal. So would you then agree, Sarah, that simplicity and clarity is perhaps where we need to be moving?
I would not only agree with that, I would beg people to do that, because although I think we all agree that's where it should be moving, I don't see a huge amount of movement in that direction. And I think particularly in the ISDS space, I always think of this, the Mark Twain adage where he says, you know, I apologize for such a long letter. I didn't have time to write a short one. But that is so true. I mean, be concise in your written pleadings. The tribunal will love you for it. On the other hand, I mean, I just had a rejoinder that was 450 pages. Repetitive, you know, didn't address the key issues. It is not only breaks my heart to get that, but I am sure that the tribunal is also very upset by that. I mean, these are human beings, and we only have the ability to digest so much information. So if you're sending pleadings that aren't well structured, that aren't concise, and that just, you know, go on and on, it's really not going to be well received. And it's kind of disrespectful for the time of the tribunal, frankly. These are all very busy people. And the chance that they're going to read your 500-page brief. Now, in response to that, I think that's where we have to be strategic, because it's very tempting to want to respond to everything that's in a pleading. But I don't think you should necessarily do that. I think you should be strategic. Ask yourself, why am I writing this? Why does it matter to my case? And if it doesn't, then say, you know what, this stuff is irrelevant, and I'm not going to address it. And I have a lot of funded cases, right? And so there's a pot of money, and you have to make a decision about what you're going to address. And when there's a lot of arguments that are just either frivolous or erroneous or don't make sense, you can respond to those in very short order, in a very concise manner that says, you know what, this is irrelevant for the following reasons. I'm not going to spend time on it. And I think tribunals appreciate that, rather than going into, you know, a 700-page response in order to hit all those points. So I think be concise, be reader friendly. So, you know, signpost, all these basic things you learned in law school about, you know, in the US, it's IRAC, you know, your issue, the rule, the analysis, the conclusion, but make it structured, make it logical, make sure there's flag posts, make it digestible. I mean, I think what we are paid for as advocates is to make things simple. I used to have this case that dealt with these turbidite reservoirs, which are essentially oil field reservoirs that are formed by avalanches under the ocean floor. And the geology is pretty incredibly complex. Interesting, but you know, if you're not a geologist, you might not think it's that interesting. And I used to have this great witness, and he was so bright, but he would just talk in terms which no one understands. So I would say, tell me as if I'm your grandchild, you know, tell me as if I'm your, you know, 7-year-old grandchild who needs to understand what a turbidite reservoir is and how it affects these reserves. And then it's by doing that and making it simple for the tribunal, that's how you will be an effective advocate. Because if you're reading technical documents and no one understands them, you're not going to persuade anybody. Mm-hmm. And then do simple things like, rules of threes. Our brains remember things in threes. So try to theme everything. Try to make it in a way that's going to be easily understandable, memorable. And I think that goes back to what we were talking about, theming cases and making it kind of a story.
Yeah, I can feel in myself some disagreement.
Okay.
But maybe this is a matter of terminology when we talk what is clarity and what is simplicity. Yeah. I have no problem with clarity because I think it's obviously a core function of advocacy to make things clear so that they are understood and they are compelling. And I agree with all the stuff about repetition and how you present and so forth. I think it's very clear. I think more conceptual difficulty with simplicity, because I'm not sure that it is a value in itself. That there may be complex cases that require you not to be simple, to be compelling, that require you to embrace and deal with and work with the complexity. It depends on the case. Sometimes there's really, it's actually not, it just looks complex, but it isn't, because behind all the complexity, there are really one or two questions that are determinative. But sometimes it's just, life is complex, and you need to be able to deal with that as well. And I think by then simplifying, you introduce a level of artificiality that doesn't reflect the case. And I think that's dangerous as well, because you can then be oversimplifying. So obviously the real challenge is if you have a case like this that truly is complex with a lot of issues that are all determinative or important, at least for the determination of the case, how to maintain clarity in these circumstances, obviously very difficult. And the challenge. But I do remember I've once submitted a 650-page post-hearing brief.
Nice.
And it's probably sort of in every advocacy course, they would tell you, please never write more than whatever 300 pages. And it was 650 pages long. And we had furious, intense debates all the way within the team and with the client, whether that's the right approach for that case. But it turns out that what it provided, and we're talking maybe about post-hearing briefs separately anyways, but what it provided on those 650 pages was a complete roadmap for the tribunal to work through a highly complex case and translate that into an award. Mm. And we could see when we actually received the award, which was a very good award, that it had really taken the structural approach in its complexity and worked through it. Yeah. But to be absolutely clear, I would not advocate that approach for every case, and maybe not even for a lot of cases. Yeah. It's just a nuance.
I agree with you, and I also think a really important part of that advocacy is to do just that. Think about how the tribunal is going to write the award. Think about decision trees, and there might be a number of decision trees if there's a number of different decision points within a case, but help them decide exactly what questions they need to address, how do they address it, and how they get to the end goal. And oftentimes, if possible, write those submissions like they could be used in the award. You know, literally, sometimes, for example, chronologies are quite helpful in that regard. Sometimes people are playing fast and loose with when things happen and how things happen. And if you can give the tribunal a fairly, objective set of facts that they can use to import and make their job easier, they will be very thankful for that. And you often find your own writing in the award because they've used that that approach.
We have a few questions on the online, and I will come to the audience here. One question from Jay Corbett, which specifically relates to what we're discussing now. Brevity and focus are essential, but clients quite often misunderstand that. they think that you're not trying hard enough or are simply surrendering if you have a sort of a shorter rejoinder to a very, very long reply. So do you have any thoughts on the client expectation management when this happens? And before you give your views, I think one of the, again, that's a matter of culture. Certain, as part of legal training, some jurisdictions, you bring every single argument that you could bring in the case rather than your strongest argument. And of course, one of the way of educating the client is to say, look, we have these 5 options, but we think these 2 are strong. And then the 3 will have them as perhaps alternatives and second alternative, and then bring them up later if needed be. But there's no reason to sort of to have all of the success and recommendation. So how would you manage a client expectation?
I mean, I've been, I guess, fortunate in the sense that I've rarely had disagreements with my clients on how to approach that. And that is because I do precisely what you just said, Loukas, like going through what the options are and most importantly, what will be persuasive to the tribunal member. I do think it's important for clients to have their day in court. Often they feel wronged and they feel that it's almost like I mean, that's why I think the hearing is so important, right? And I think we always talk about virtual versus in-person hearing. I think there is something to a client being before the judges, looking them in the eye and having the opportunity to say, this happened to me and I'm upset about it and I want you to decide my case. But I think if you have a conversation with your client about the benefits of approaching it in a way that's going to be more persuasive to the tribunal, ultimately they want to win the case. And you know, sometimes they'll be insistent on a few tweaks because that's really important to them for whatever reason. And there has to be compromise in that regard. But I think typically clients realize that they hire us and pay us, you know, for our guidance in relation to how to persuade the tribunal. So typically speaking, most clients have been quite open to that.
And my case too. I think the one case that I remember where it was difficult to persuade the client was the 650-page post-hearing.
Yeah.
But it's interesting what you said, Loukas, about sort of parties putting forward every single argument that one can come up with, which I think is highly ineffectual. And I think it is a little bit more in civil law countries than it is in common law countries. And it also, I think, comes from a court tradition where you put in arguments because you're already setting up for appeal, right? You're putting arguments that maybe then you can say on appeal that this argument hasn't been considered and so forth. Yeah. So it's obviously this doesn't make any sense in front of an arbitral tribunal.
I mean, given that the session is recorded, I would have given examples of this sort of over pleading the case, or to bring every single argument, where you have a good case but it's buried under 5-6 bad arguments, and then the tribunal will not go for you, even if you have one strong argument.
And the bad arguments, some of them are so bad that they take away credibility, right? That's...
Hello, this is Sayed. So sometimes do you, a case which is relatively simple, do you make it complex in order to get certain outcomes? For example, in a case where you want delay, expect
strategy. I mean,
it's a fair question. Yes, I can see how that could be a strategy. Yeah. I think that it could be a strategy. I just struggle to come up with a really compelling example from my practice, from my recent practice.
Well, I could give you an example. If you have a party claimant, for example, that is represented by a sole practitioner of a very small firm, and you represent the respondent, which is a very big company, there's nothing wrong with providing a reply which is 700 pages, 200 exhibits, 200,000 exhibits. It's easy to do it.
Sure.
Yeah.
Sure. I'm struggling with the sort of, if it's a very simple case to write 700 pages, because I think you can stretch it only so far. Yeah, but yeah.
Not a very simple. Yeah.
I just find that sort of over the last years, speed and cost have become such prominent topics in international arbitration that a delay strategy, I think today is a high risk enterprise, because everyone is so mindful of the policy arguments and the problems with delay, that I think if you're seen to delay, I think it's really damaging to your position.
But I have seen that a lot, especially with respondents. So yes, it is damaging, but at the same time, if they don't have to pay an award for 3 more years because of and you can muddy the waters. I mean, I think an approach that is often taken, especially by respondents in ISDS cases, is to put everything in the kitchen sink in. Everything you can think about. Might not have any basis in reality, but just throw it in there. Corruption, I mean, you name it, just make it up and say it. Because although it might not be true and there might not be significant evidence for it, you have to respond. And so you're going to force the claimant to have longer pleadings, to spend more money, to make it a bigger case than it is. And I've seen that a lot in that context.
And it does make sense as an advocatory strategy for a respondent to create more hurdles, right? Because every hurdle is another hurdle that the claimant has to climb to succeed. And you never know, maybe there is a hurdle that you didn't think was particularly strong, but it's the one hurdle where the claimant fails in the end. So I can see the logic of it.
There's a question here first, I guess.
How hard is these days to deal with media misinformation? And it is advisable to base or support the facts on media or news, because there's a lot of information that is like everyone can invent or tell a part of the story that is entirely true.
Fake news. Yeah, it's everywhere, isn't it? I haven't had that many cases turn on it, but I could see where cases might have very different approaches. I mean, certainly, typically what I find the most compelling documents are documents between the parties that are negotiated, contracts, deals, correspondence, which aren't really about the news, right? And I think you have to be careful about news sources, because they're of varying, repute. And so sometimes it's the case where you might want to, we were talking about this earlier, get a private investigation firm to come in when you're building a case, if you have certain concerns, to do some investigations about the other side. That goes, whether you're claimant, whether you're respondent, and sometimes there are things in the press. I just think you have to be, before you make an allegation, you should make sure that there's something to it. Because what I find not compelling, especially if I'm sitting as arbitrator, is lots of allegations that don't amount to anything. Then you start becoming that person who cries wolf, and you make these allegations and you have nothing to support them. And the bars on these things, like corruption, they're very high bars. So you need to have some evidence to support your case. And I find that when parties just allege things to try to muddy the waters, that doesn't come out as particularly persuasive.
Something like that, then it has a strategic purpose. And if you think that's the right thing to do, okay. It's usually not all that effective, I think, and you have to weigh that against really alienating the tribunal as well. If you're litigating everything and everything ends up before the tribunal, every small issue at some point, and it's always you who brings it to the tribunal, you will not have made friends by the time you go into the merits here. So, having said that, sometimes you need to stand your ground, and sometimes I found that you try to professionally work something out with the other side, and it doesn't work. It's obviously always the other side's fault then.
Always.
But then you have to stand your ground, and then you litigate because that's what you do. So I would. Two things. One, I would always ask, what is the strategic purpose to be difficult about a particular issue? But secondly, if I think it makes sense, then don't shy away from the fight. Yeah,
I would only add, I guess, 2 things under that. One is karma. Yeah, I believe in karma, and I believe that if you're a reasonable counsel, you're going to need a favor sometime too. You're going to need an extension. Something's going to happen, and you're going to need to be flexible with the other side. So karma, I think always treat people with respect and it'll come back to you. And second, I don't think it's so much, I know we talk a lot about civil law versus common law, but I almost see it as like a diagram of arbitration law, right? Like, and I think if you're dealing with other firms or counsel who have experience in arbitration, whether they're from civil law jurisdictions or common law jurisdictions, I find that it's easier to deal with than, for example, my worst experiences are also with annoying American firms who are just, they want to litigate and they want discovery and they want, they don't really understand, how we should, be civil, and there's certain principles that should work. So I think it's less about the legal culture as it is the familiarity with the arbitration practice and how one should conduct with it, yourself within this relatively small community.
Yeah.
So you get a reputation for how you behave as counsel. And some people, I think most people have pretty good reputations in this regard, but there's a few that don't. So,
I mean, imagine a situation, the counsel from the other side calls you up and says, I have technical difficulties. Our computer system has crashed. We need an extra day to file. Imagine you want to say no to that. Okay, you can't say no to that. It goes to the tribunal. So the tribunal will be thinking, okay, what kind of people are these, right?
Yeah.
They say no to something that can happen to anyone and is sort of bad enough. But then think further. What if your case is about good faith and you're hammering good faith in your case? And then you've been the person who's just told, the other guys, bad luck on your computer problem. So everything hangs together. Does it make sense?
Yeah.
Yes.
I have a question regarding I'm Hassan, by the way, before I start my question. I have a question regarding the remote hearings or video conference hearings. To what extent the non-verbal communication with the tribunals matters in the award? The reason why I'm asking this, because it might be in the future, especially after in the post-pandemic world, we might have new technologies taking part of the future arbitrations, such as the metaverse.
Metaverse.
And this particular question is so important to me because in the metaverse, after I tried it, it has like some specific pre-programmed reactions, facial expressions that might not help the counsels or the arbitrators to be able to interact in a non-verbal way of communications.
Can I, although I'm not the speaker, can I attempt an answer to that?
Yeah,
Absolutely.
I think when everyone who talks about advocacy speaks very much about body language. And it happens very often, and I have seen it in hearings as an arbitrator, where you have a counsel who is a bit younger that turns completely red to the extent that the tribunal is panicking because you do not know this person might collapse, which of course the person never collapses because it's human. It's a human reaction, but it almost intimidates you. And actually, there was one case where one of the advocates, a very, very good advocate, had a very slight speech impediment. And the other side, obviously, there was a bit of discussion amongst the tribunal. There was nothing that was disruptive to the hearing as such, but it was something that you noticed because the way this person, the way she was trying to overcome this slight speech impediment is to always develop a way of speaking like you are in a BA flight and you have an announcement from the flight deck. Which of course one member of the tribunal made it, which was a very inappropriate comment in so many respects, but it distracted from hearing the argument. So I think, unlike the metaverse, in real hearings, advocates and arbitrators are human. So I think there's nothing wrong if somebody sort of starts coughing and does will and covenant. Just take a sort of slow down, and sometimes it's the role of the tribunal to say, is that a good time to get sort of a bit of a sort of
time for a comfort break.
But because I've seen it happen, and the person who turns red and almost is intimidating the tribunal could be a terrific advocate. So if you just forget to look at the person and focus on the argument, for example, you might get a very different story. But that's
well, I was going to say not so much in relation to this, but I do miss in-person hearings for that reason. I think there's no better feedback than looking at a tribunal member and seeing, I mean, you can see a lot of things. One thing is they're bored. They don't like this argument. Move on. You know, there's so many things you can tell by just gauging. I think the best advocates I've ever seen in my life are those who read the tribunal and respond accordingly. They listen, they see, they get those cues. They're like, actually, I'm getting traction with this. I'm going to go further on this one, or I'm getting no traction. I'm going to move on. And sometimes it's surprising to you. It's not what the tribunal is interested in is always, it's not always what you think they would be interested in, right? So when a tribunal member asks you a question, listen.
That's like,
that is gold.
Yeah.
Listen to that. Take that on board and really, not, you know, it's in hearings, it's obviously if they ask questions, you want to really focus that on, and on post-hearing briefs, you want to make sure those are addressed thoroughly. But even they might be telling you things in the way their correspondence is written or their responses to your disclosure applications. You want to just get every cue you can from the tribunal because they will make the decision. So in terms of, you know, I don't know, I've never done metaverse and I'm terrible technology-wise. You can ask any of my associates, I'm awful. But I do miss that, you know, eye contact. And I think for the hearings, there's also a sense of, you know, this is formal, this is credible, this is, the person is getting their day in court. And their day in Zoom is just not as exciting as the day in court. And I think it does matter for the parties.
It's a super interesting. I mean, you can tell we're all like thinking about your question, and it's really engaging because that's been our life for the last 2 years, right? And I think we've all, and I know I have been thinking about it a lot. I think my natural response and my natural inclination is very much how you have just described it. I have to say though, that it also has advantages, the video setup, in exactly the same way that we've just said it doesn't. What do I mean by that? For example, the camera really comes a little closer to people, right? So you almost see the face, you see more, you see less of the body in terms of body language, but you see more of the face. So you actually pick up on facial expressions of witnesses or indeed of the tribunal in a way that you might not even in a physical hearing when you have a very large hearing room and you're just a little bit further removed, particularly when you're short-sighted like I am, but I like the screen very close. I found that very interesting to be able to watch in that way. And it's exactly like you say. I think having an eye on the tribunal and how they react, and feeling whether you get traction or whether you don't, I think that's A, really exciting, and B, really, really important. And I feel that you can do that on a virtual hearing as well. I've also found that cross-examining witnesses over video is not as difficult as I thought it would be when we first did it, whatever, 2.5 years ago now, on a more regular basis. Because there's something, it creates sort of a tunnel, right? Because there's really just you and the monitor, and in both directions. There's no distraction, and there's also less opportunity for the witness to look sort of through all kinds of physical bundles, because the document that you show is also on the screen, and only what you want to show him is on the screen. So it's a very focused exercise, actually, in many ways. So there are things that it's just different, and you need to utilize it. I am less sure whether you can take all these things into the metaverse proper, where you replace people with avatars that actually don't have faces and just whatever. Yeah. So I'm yet to be convinced that this is the future. I'm putting my money more on sort of a holodeck where you can virtually meet them. Thank you so much for you.
We nearly reached our time, actually, the whole allotted time, but there's one question, and I think, go ahead.
Yeah, hi, I'm Michael here. I'm just going to ask a question which is kind of takes more of a bird's eye view of the overall process. And it kind of relates to is there actually any scope for arbitration between private parties nowadays, which isn't adversarial? I mean, a lot of what I've heard tonight could equally apply, in my opinion, to the High Court down the road in the trial, where you're talking about strategy, case theories. And I think with this kind of recognition, growing recognition in practice, or at least I want to get your opinions as practitioners, is there a trend towards a more non-adversarial approach to out-of-court dispute settlements, such as arbitration, where there's a binding resolution at the end, considering the commercial, and I think you, Sarah, you alluded to at the beginning, this idea of the commercial relationship, depending on the commercial relationship and the importance of that to the clients. If it's a long-term supply contract, which is relational, for example, how much does that determine how adversarial in practice a particular arbitration will be? Or is it always, once there's a dispute and you're engaged, it's pretty much like a court trial and you've got to win or lose, and it's very much almost the relationship kind of falls away? I mean, is that a trend? This kind of more relational, commercial relationship driven view of arbitration, or am I just thinking about a pipe dream?
Yeah, no, I mean, I think it all depends on what the client wants out of the process. I just have a Canadian there, process. Sometimes that I'm from Michigan, and sometimes that my friends to the north come out in my accent sometimes. Yeah, I mean, so I think the level of how adversarial you're going to be, how aggressive you're going to be, that all comes down to what your client wants to achieve out of the arbitration. I mean, you know, if they don't want a binding resolution and they want to have settlement, there's nothing that stops parties from agreeing to then go to either settlement discussions or mediation discussions or get somebody involved, as long as both parties agree. But, you know, arbitration is in and of itself an adversarial process. And so you're always going to be, yes, fighting your case. That doesn't mean you can't be civil. That doesn't mean you can't come to a resolution. And sometimes, you know, I am a fan of negotiated settlement, because a lot of times you can offer things in settlement that you couldn't get in arbitration. For example, let's say I've got a oil and gas block, an offshore block. Maybe I can get an extension to my PSC through this process. You know, I'm not going to get monetary damages, but I can actually operate longer in the country. So that might be something that, and on the other hand, the host state doesn't have to pay me out quantum, which is helpful to them. So I think there are some solutions that you typically can't get, because it's very unlikely you're going to get, you know, specific performance or a tribunal who's going to allow you to extend at least beyond what the parties had agreed. So there is a place for it. But I think the arbitration process itself is really meant to be adversarial. That doesn't mean you can't jump out of it if you're in, take a break and take a breather, if that's what your client wants and you think that there's a good prospect. And frankly, sometimes cases should settle, because the amount of money that they spend on Franz is too much. This doesn't, you know, it's not value for money. Yeah, but if it's a small dispute, it might be, you know, I mean, when you look at the cost of investor state disputes, for example, I think the average cost is about 6 million. If it's unsuitral, it's going to be, you know, 7 million. So that's 14 on both sides. Is there a happy medium we can find, you know, that we don't have to spend that much money on lawyers? And I think lawyers should be open to doing that, open to doing what's best for our clients. And if that's to move forward with commercial relationships and not fight to the bloody death, that's what we should do.
Yeah, I completely agree. And I think this is also one of the first things that you discuss with the client, and that any sophisticated client will tell you, in fact, that this is sort of a dispute, but there's an ongoing relationship. And that often happens in the real world, that parties have been unable to find an amicable solution. So they go into arbitration and they need a decision. But at the same time, they have other contracts going on and other ways where they work together, right? That are still important to them. And very recently, I had a case. It was an arbitration that was going on for 4 years, and it was quite brutal. It was certainly very adversarial. And this has been concluded about a year ago. And last week, I got an email. I thought these clients, they hate each other. I mean, the hearings and everything. The atmosphere was really tense. It was one of those, right? And last week I get an email. It says, Franz, you won't believe it, but we are thinking about entering into another contract with their counterparty because, you know, in that industry, there are only so many players. So you'll, as often in life, you see everyone at least twice.
Yeah.
I think that's actually a very good question. And I think there is a bit of a tension here. I think the council generally prefers an arbitration which is adversarial in allowing you to develop the case the way you want, unless you have a very good tribunal that you can trust fully. And tribunals, and primarily arbitral institutions, expect tribunals to be a bit more inquisitorial. I hear more and more tribunals speaking about party-appointed, tribunal-appointed experts. I see more tribunals where they push the parties to agree on certain matters, sort of. And of course, a lot of that is being lost in the online environment, because if some of that happens in a real hearing, where in the coffee break, so people meet and sort of after they have been to the sort of private rooms with their own clients, a lot of more of that was happening, and I think some of it has been lost for the last couple of years.
Sure.
And that's perhaps the biggest sort of major problem with that. We've seen fewer settlements because parties don't talk; they don't have an opportunity to talk. Of course, counsel often will pick up the phone. That is not the case. So institutions want arbitrators, and a lot of the very prominent arbitrators are, let's say, of a Swiss disposition, so to be a bit more inquisitorial. And you see even retired English judges acting in arbitration becoming a bit more inquisitorial rather than adversarial.
And I do think there's something critical about getting the two parties in a room together to discuss it. Because, I mean, first of all, there's perhaps some different incentives. The lawyers want to continue fighting and, doing their legal work. But really, it's up to the clients, and they're the ones that can resolve the dispute. So I think there is really an advantage to having them meet, discuss, and work things out. I mean, business people can usually work things out so much better than lawyers and so much more quickly than lawyers.
And I think there's also sometimes at least a strategic advantage of keeping the two processes separate, right? Yeah. You don't want to get your legal team on the eve of client into settlement mode. You want people to, focus on that, and maybe you'll have a separate track that looks at the commercial solution, populated with people who can do it.
One thing I've done, and it hasn't worked, but I'm going to keep trying, is that I'll say to opposing counsel, I'll say, look, if it's a case that, has prospects of settlement, let's touch base 2 weeks after we file each of our pleadings and just see, that way there's no stigma that I'm calling you to talk about settlement. No, every 2 weeks after the pleading, let's have a chat. Does it make sense for the parties to get together? And at least then there's a protocol in place where both parties, will think back to settlement, they see the new evidence, and sometimes they'll see the additional legal fees at each stage, and it might make sense then to come to the table and talk about things. So, and that's just a way to do it from the very beginning, and say, look, we're going to meet every 2 weeks after a filing, and is it time for our clients to have a conversation? One thing I really don't like is lawyers who don't allow their clients to be copied. I hate that because I find that lawyers often just, might really be acting actually in a way that is very adversarial. It's racking up costs. I think if their clients were involved in the decisions, they would be very upset about that. So I really am a fan of having clients copied and all the tribunal correspondence and all the pleadings so that they know what's happening. And when I sit as tribunal, I prefer to have client representatives involved in the process. It's their process. We're doing this for them. So they should understand what's happening. And
a lot of tribunals are now insisting on having party representatives, particularly at the beginning, when you set out the schedule for the case, so that the lawyers don't. Oh, that's not good for me. Yeah, exactly. Yeah, exactly. No, I think that's very good.
I have to say that we're a bit 10 minutes after the time we have allowed ourselves, and we're only about halfway our list of issues. So we effectively largely dealt with pre-hearing advocacy, but and there were a lot of very good questions on the Q&A. There's one question that comes from a colleague who I assume is based in Japan. So as a matter of I will take that question from Colin. And that's the last question. He was asking whether the recent ICC work on the importance of documents and witness hearing has, rather witness memory and all of that, whether you think that has had any impact so far on the way evidence is being handled.
I think it's given a greater awareness that there's an issue, right? So I think now we all understand that witnesses have imperfect memories, that just the way that the memory works is problematic. So I think it has had some impact. I don't think anytime soon we will come to a world where we're not going to have witnesses or where we're not going to rely on those witnesses. That is, these are their stories. We're telling stories. And so it's important to have the various actors come before the tribunal. And, even if the memory might not be exact and it might have faded in some respects, I think sometimes, although the studies say we're terrible judges of people, I think you do get a sense of the case by listening to the parties who are involved. And I think it can be quite helpful to have witnesses testify. So I don't foresee witness testimony going anywhere anytime soon, but I do think that now there is a recognition amongst arbitrators and the arbitral community that there are problems with witness statements. And we always knew there were, right? I mean, right. And we always knew that the lawyers drafted those statements. And so now I think we're just a bit more open about those things.
Yeah. Or you choose one or another witness to come forward.
Exactly.
I mean, I haven't seen it, but I think it would be interesting if someone in a post-hearing briefs made a specific argument based on scientific theory about the reliability of a particular witness testimony in the case. It's obviously difficult for lawyers to make because it's not their actual field of expertise.
So, thank you very much. I think I speak on behalf of the school and indeed all of the audience. It's been an absolutely fascinating discussion, and it will go for much longer. So I will ask you to join me in thanking the speakers and also join them for the drink outside. Thank you very much.